I'm David Snyder. I'm a professor of law at American University at the Washington College of Law. I'm also the director of the business law program.
Can you provide a 3 to 4 sentence overview of the project and its goals?
Sure. Our project is about protecting the human rights of workers in international supply chains and also to protect similar values like environmental sustainability. And the idea is to do that by harnessing the power of the contracts in the supply chain. A lot of companies have commitments to these sorts of values, but those commitments often reside on the web where they don't really do much good, and our aim is to get them into the contracts where they can be legally effective and operationally likely. That's our mantra, legally effective and operationally likely.
How did your work on supply chains and model contracts begin?
Well, it started with sweatshop scandals in the 1990s, and back then there were these horrible revelations of child labor and slavery, modern slavery being used in the making of sportswear, sporting goods, apparel, that sort of thing, and there was a great outcry. And one of the things that the companies started to do was think about, okay, can we do anything in our contracts? And they started to do some stuff, and as a contract law professor, I thought, well, let me try to see what's going on. And it's actually really interesting to look at what the companies were doing. These were first attempts, and it was interesting the different ways they went about them, and I started writing about it back then in a book I was working on international sales of goods. And my co-author and I think, were the first really to bring this into the academic discipline of contract law. Then, shortly after that, the American Bar Association was working on some principles against child labor and forced labor, and through the business law section of the American Bar Association, which I'm very much involved in, there was a big effort, pretty successful, to get companies to adopt these policies. And so the companies were doing it, but one of the things that worried me while everybody was patting themselves on the back was, are these actually going to change anything? The companies say, yes, we will commit to this, but how is that going to actually affect life on the ground for the workers? That's how I got started with this. And, there's one other piece. My field is contracts and commercial law, including their international aspects, and I do a lot of work on the international contracting. That's something I do. If there's a big problem with that, I feel like there's a moral obligation for people who are involved in it to try to fix that problem, and that's what this project has been about.
Has this work evolved over time, and what are the most recent developments?
Well, there's actually been quite a lot of evolution, and there are lots of recent developments. So after I had made the point in the ABA that these policies that the companies were adopting may not be operationalized, to use the business jargon, unless we got them into the contracts. Of course, what happened is I was then asked to chair a working group to try to fix that, and we thought the best strategy would be to adopt model contract clauses or draft model contract clauses that the companies could use. And so we went ahead and did that, and we drafted them and we published them. We call them now MCCs 1.0, Model Contract Clauses, the first version. And they were about addressing the actually very interesting, very difficult problems of contract law and commercial law that come into these issues. And to understand that, recognize that the law of sales is really focused on goods and money. And horrible as this is to say, child slaves can make great soccer balls. So if the soccer balls are delivered and they're fine and nobody knows that they were made by child slaves, now what? So far as commercial law is concerned, everything is fine. And you could add a warranty that there will be no child labor, no forced labor, and so on. But if it doesn't affect the goods, then what damages are there? How do you deal with the remedies aspect? I could go on about that, but it's actually a really interesting problem of how to deal with this from the standpoint of contract law. That's what we tried to do in MCC's 1.0. So we published those, and somewhat to our surprise, there was quite a lot of attention and interest from lots of different sectors. We were aiming mainly at the companies, but there was interest from labor unions and NGOs and civil society and so on. And we got a lot of feedback, and we got some suggestions, and we got some pushback, and we tried to listen to what we were hearing. And as I said, there was a lot of it. And in light of that, we did a much bigger, much more ambitious second version, which is coming out now, and that's Model Contract Clauses, or MCC's 2.0. And that's what's going on right now. We have put those out somewhat unofficially on the web. They will be officially published. They're not endorsed by the American Bar Association Business Law section, but they will be published by their journal, which is the main business law journal in the world. It's called The Business Lawyer, and they will come out this winter, so in the next couple of months, and we are already getting lots of requests to present our work, explain how it works to trade associations, to companies, to those in different sectors of the economy, investors, and so on. So we're actually quite busy, and that's what's going on right now.
So what are the main challenges you faced in developing the model clauses?
Wow, that's a great question. There are a lot of challenges. I think let me hit on 4 of the main challenges. One, I hadn't really focused on before I started this work. I should have seen it coming. I just didn't entirely. And that is the reality that not everyone's interests are aligned. So when we started the project, it was mainly business lawyers trying to help businesses deal with these issues. But once everybody saw what we were doing and got so interested, we were dealing with lots of different groups. And the reality, the cold, hard fact, not everybody's interests are aligned. So big Western brands, the buyers, their interests are going to be different from suppliers. So first-tier suppliers, often in the West or the developed world, may not have the same interests as the suppliers in the developing world. And workers have different interests, and NGOs have different interests, and different parts of civil society have different interests, and investors and banks and so on. So, we're just trying to navigate that reality that not everyone's interests are aligned, and we're trying to come up with clauses that will work as a model. So that's one. 2 is something we all knew about, that companies are in different places. Some are very advanced, really want to work on this. Some sort of want to work on it, and maybe they will, maybe they'll get around to it, maybe they won't. And then there are a number of companies who are just tempted to bury their heads in the sand. And so that's a big issue of, if we look the other way, maybe this problem will just go away entirely. And then there's a more active kind of challenge where companies say, look, if we say we're going to do all this, that's more cost for us, more expense, more risk, more exposure, and so on. How could you be telling us to do this? And we do have an answer to that, which is that by ignoring this, it doesn't mean there's no cost there. Your cost is a significant legal and reputational risk. And sometimes that will, come home to roost. And we have plenty of stories where companies ignored the human rights aspects and it turned into a big problem and the whole project cratered. And this is sometimes millions, tens of millions, hundreds of millions of dollars, especially in the extractive industries like mining or oil and gas, where the whole project craters because of this. And our point is, what we're trying to do is help you recognize and manage your risk. You can say that it's expensive, but it doesn't help if you say, oh, well, we have no cost right now. You do have cost. What you have is this serious risk. And so we're trying to help companies see that and manage their risk. A third big issue I sort of alluded to a moment ago, which is very mundane. It's just about priorities. Lots of companies are like, yes, we understand the risk. We need to do something about it. There's regulation coming this way. Some of it's already in effect. We need to deal with it. We'll deal with it. In fact, it's number 6 on our list. Here's my list right here. We'll get to it. Okay, the problem is they never get to number 6. You have a list. You're lucky to get past number 4. And so that's a big challenge. That is one of the things we're trying to address by making it easy. Say, okay, we know this is on your list. Here's some model clauses. You'll have to adapt them to be right for your industry and your company, but it gives you a really good starting point. And I'd say the fourth big challenge is companies really want more from us than we can give. And this comes back again to something I just mentioned, which is that these are model clauses and they are not company specific or even industry sector specific. So companies often say, yes, we're so glad you have model clauses, give them to us and we'll just put them in our contracts. So we're like, whoa, you do have to adapt them so they work for you. And let me explain the problem this way. So if it's an electronics maker, they probably have to deal with rare earth minerals. So in your cell phone, there are all these minerals that are hard to pronounce, and they come from often troubled areas of the world, and these are conflict mineral problems. So electronics makers have to be very focused on that. Apparel makers, the big clothing brands, they don't have to worry about conflict minerals. So that's no problem for them. Their problem is cotton. Cotton being picked or processed by forced labor, and that is a huge issue right now. And of course, electronics makers don't have to worry about cotton. We can't provide everything to the whole world. What we have given is a set of what we call building blocks. So each company in each industry sector can focus on what it needs to focus on in terms of stating the specific standards that will apply to their contracts. But that will be some work, and that is, of course, a challenge.
So where is your work on this issue headed next?
Well, right now we're super busy dealing with MCC's 2.0, but there is a 3.0 that is a glimmer in the future, and we are beginning to think about that. There's beginning to be some interest in that, and that is about harnessing technology and harnessing current cutting-edge supply chain management techniques. So managing supply chains is a really big deal. And you can get a whole master's degree in just supply chain management. And these things tend to be focused on keeping costs low, keeping production on time, keeping quality up, that sort of stuff. And how do you deal with that, especially when it's halfway around the world? Well, the answer to that is a lot has to do with technological innovation. What most people are talking about now is they're talking about blockchain. It's not necessarily blockchain, it may be other distributed ledger technologies, but same idea as blockchain, or simpler things that have been around for decades, like RFID, like the stuff you actually probably see on products in the department store or the grocery store, or other devices that can be used to figure out where are the goods, how are they moving from point A to point B. That's, as I said, mainly about traditional core business values, low cost, efficiency of production, just-in-time inventory, that sort of stuff. There's no reason that those same technological innovations can't be harnessed to deal with human rights and sustainability issues. And MCC's 3.0 will be really looking at that, and I think that'll be a really exciting development. And I think when we look at being effective and being operationally likely, it's got to be about technology.
Are there any takeaways about this project for law school students specifically?
Yeah, I really think there are, and it's a big one. So when you're in law school, you often think, okay, well, they're the business law types and they're the human rights or public interest types, and like there's a big divide between them. And one of the things I hope that law students can see from this from this project is there doesn't have to be that divide. Often there's this sense that people going into business law, they're representing businesses, they're all about the business's interests, and that's all about money, and that's all there is to it. But what we need to recognize is those businesses have a huge impact on the world. Those businesses, business organizations, that has a lot to do with how we live our lives, how our society is organized, and in fact, how a lot of the world works. And so the lawyers working for those businesses are really well placed to have a big impact on the world because those businesses, their clients, have a big impact on the world. And this is not to say that there won't be time spent on mergers and acquisitions and securities issuances and that sort of stuff. But one of the things business lawyers do is deal with both complying with law, and there is law around these forced labor values, child labor, and so on. I won't go into all of that. Part of it is about dealing with law, but part of it is about doing what the companies want. And the companies want to do this. This partly has to do with things that you've been hearing about, ESG values, environmental, social, and governance values. The companies care about that, and they're forced to care about it. I actually think when you think of the board members, you think of the officers, these are people, and so they want to do the right thing. And then they also have a really strong incentive to do the right thing, partly regulatory, partly coming from reputational matters, like their customers may care about it, and then what may be the biggest one, investors nowadays care about it. And that, of course, drives a lot. So I'd say the big takeaway for law students is by pursuing business law, there's lots you can do that has a really positive impact on the world. And if I can do anything to encourage you to do that, then I've been successful.